So still on the subject of property law, now let's talk about ownership. So what are the rights of an owner? So we have first, jus possidendi, the right to possess the property owned, malamang, diba? Jus utendi, the right to use and enjoy. It may also include the right to exclude any person from enjoyment and disposal of the thing. Jus fruendi is the right to enjoy the fruits of the property. So fruits could either be natural, industrial, or civil. Jus disponendi is the right to dispose the property. Jus accessiones is the right to the accessories of the thing. Jus abutendi is the right to abuse or to consume. Jus vindicandi is the right of action against the holder and possessor of the thing or right in order to recover it. Jus treasuris is the right to hidden treasure, and right to receive just compensation in case of expropriation. So very self-explanatory na kapag owner ka ng isang property is may right ka to possess it, to use it, to abuse it, to do whatever with it, to dispose it in the form of like selling it if you want, or kung ano man yan. So, as an owner, yan yung mga rights mo over the property. Basically, lahat. Kasi sa'yo yan eh. Real rights, it is created by mode and title. A real rights object is generally a corporeal thing, and there is a definite active subject who has a right against all persons, generally as an indefinite passive subject. So, real right. Sa'yo yan eh. So, dahil sa'yo yan, pagmamay-ari mo, hindi pagmamay-ari ng iba. And kapag real right, usually, for example, lupa. Sa'yo yung lupa. So, hindi mo kailangang i-impose sa iba talaga na sabihin na sa'yo yan, pero dapat alam na ng buong mundo na sa'yo yan. Na ikaw yung may right sa property na yan dahil ikaw yung may-ari. So, it is directed against the whole world, giving rise to real actions against third persons. Generally, it is extinguished by the loss or destruction of the thing over which it is exercised. Personal right naman is created merely by title. A personal rights object is always an incorporeal thing, and there is a definite active subject and a definite passive subject. It is binding or enforceable only against a particular person, giving rise to personal actions against a debtor, for example. So, there are limitations on ownership, however. Diba sabi ko parang kapag ikaw yung may-ari, parang halos lahat pwede mo nang gawin. Pero syempre, merong limitations, and that is and those limitations may be given by the state, or given by the owner himself, or given by the person who gave the thing or transmitted the property to its present or owner, or specific limitations on ownership. So punta muna tayo dun sa limitations na binibigay ng state. So, na-discuss natin sa Consti Law na merong police power, power of taxation, and power of eminent domain, yung state. So, police power, limitation on the right of ownership in the sense that the property may be interfered with or even destroyed kapag ka, quote-unquote, noxious yung property, especially if the welfare of the community so demands it. Like, for example, you own 10 grams of shabu. While you may do anything with that 10 grams of shabu as its owner, pero merong limitations, such as the police power of the state na pinagbabawal yung shabu, hindi legalized yung shabu dito sa Pilipinas. Therefore, even if you own shabu, pwedeng i-confiscate ng state, hindi kanya bibigyan ng compensation dahil, for example, gumastos ka ng money to buy that, hindi ka i-reimburse ng state dahil kinonfiscate yung shabu mo and dinestroy. That's an exercise of police power. Same with whatever that is contraband or illegal, di ba, pwedeng kunin yan ng state kahit na sabihin mong owned mo yan, pero pwede pa rin kunin dahil may police power yung state. Pwedeng i-regulate yung ownership mo. May limitations. Like for example, counterfeit items, like it's yours, pero pwede pa rin kunin ng state dahil violation of intellectual property, for example, mga ganyan. Real as well as personal property may be taxed unless taxes are paid. So, yun. So, there is a danger that property may be seized and confiscated by government if hindi nagbayad ng tax. Another is, for example, pumunta ka ng abroad, tapos namili ka ng mga bagay-bagay doon. So, dapat i-declare mo yun sa customs bago ka bumalik dito sa Pilipinas, and kailangan mong bayaran yung mga kailangang bayaran na fees. So, pag hindi mo yun binayaran, or pinuslit mo, tas nahuli, di ba, pwedeng i-seize and pwede kang ma-punish or ma-penalize because of it. So, while it is yours, and while you used your hard-earned money to obtain such property, but still there are limitations to your exercise of ownership over a property. So, the state has the right to acquire private property for public use. So, napag-usapan na rin natin sa PolyRev. Check nyo na lang yung Political Law Review playlist, yung just compensation, yung concept ng power of eminent domain. So, for example, meron kang house and lot, tapos, yung lote mo is situated sa isang lugar, for example, sa tabi ng highway, tapos magro-road widening sila, so maapektuhan, 'di ba? So, wala kang choice kung kukunin ng state yung property mo as long as babayaran ka naman ng state ng value to it. Pero hindi mo pwedeng insist na ay property ko yan at ayaw kong bayaran nyo ko. Gusto ko i-keep yung property ko. Hindi ko ibebenta to sa gobyerno. Wala kang choice kasi kapag na-fulfill naman, meron namang due process, so hindi naman magiging unfair sa'yo. Although, kunwari gusto mo talagang i-keep yung property, ayaw mo ng money, wala kang choice kapag ka for public use and may just compensation, may public purpose talaga. So those given by the owner himself, so for example, this is also given by the owner himself and by virtue of a contract. For example, meron kang property and then pina-Airbnb mo, 'di ba? Or pina-rent mo. So, dahil pina-rent mo, meron kang lessee, tapos ikaw lessor, hindi mo pwedeng i-exercise yung right to possess your property. Dahil, ikaw din mismo nag-impose sa sarili mo by entering into a lease agreement na ipapalis mo sa iba. And dahil ipapalis mo sa iba, malilimit yung rights as an owner over that property dahil yung lessee mo yung may right to possess the property kasi nagbabayad naman siya ng rent, nagbayad naman siya ng advance, nagbayad naman siya ng deposit. So, hindi mo pwedeng sabihin, ay ako yung owner yan, pwede akong pumasok anytime. Hindi pwedeng ganon. Those given by the person who gave the thing or transmitted the property to its present owner. So, for example, merong imposition, like for example sa succession, may legacy na iniwan sa'yo, pero lupa kunwari, so sa'yo na yan, 'di ba? Pero merong condition, and that is bawal mong i-alienate or i-dispose yung property or ibenta for like 10 years, ganon. So, is it valid? Yes, it's valid kasi nasa succession laws natin na up to 20 years na pwedeng i-prohibit na ibenta, for example, yung property na binigay. So, since bigay niya yan, di ba? Meron ding mga donations na conditional, di ba? Merong mga ganon. So, dahil yung act of benevolence ang nagbigay, di ba? Binigay niya sa'yo, so sa'yo na yung property, pwede siyang mag-impose ng conditions. Therefore, malilimit yung rights mo as an owner kahit technically sa'yo na yung property. Specific limitations on ownership such as those imposed by law. So, pwedeng gumawa yung Congress ng kahit anong batas dyan na pwedeng malimit yung rights mo as an owner if nuisance yung property mo. So, pag nuisance yung property mo, that is, yung property mo injures or endangers the health or safety of others, annoys or offends the senses, shocks, defies or disregards decency or morality, obstructs or interferes with free passage of any public highway or street or any body of water, or hinders or impairs use of property. So, pwedeng i-destroy yan. State of necessity. The owner of a thing has no right to prohibit the interference of another with the same if such interference is necessary to avert an imminent danger and the threatened damage compared to that arising from the interference is much greater. The owner may demand from the person benefited indemnity for the damage to him. So pretty much self-explanatory if it's for public order, public safety, or public health na kailangan i-limit yung rights mo as an owner, wala kang magagawa, di ba? Pero, babayaran ka naman for damages suffered. Easements. Voluntarily imposed by the owner. So, mas mapag-uusapan natin yung easements later. So, for example, right of way. Kailangan mo magbigay ng right of way. Mga ganong bagay. Servitudes. So, once requisites are satisfied, the servant owner may ask the court to declare the existence of an easement and mortgages imposed by contract. So, for example, meron kang bahay pero pinamortgage mo, real estate mortgage mo. So, nililimit mo, diba? Dahil nag-enter ka into mortgage agreement, yung rights mo as an owner. So, mas pag-uusapan natin yan later, yung mga concepts ng easement, servitude, mortgage, mga ganyan. So, ngayon, parang stick muna tayo sa topic ng ownership, rights of an owner. The owner of a thing cannot make use thereof in such a manner as to injure the rights of a third person. There is an inherent limitation on the right of ownership. The owner of a parcel of land is the owner of its surface and everything under it. And he can construct thereon any works or make any plantations and even excavations which he may deem proper kasi property niya yan, without detriment to servitudes and subject to special laws and ordinances. Meron nga parang, for example, pwede kasing ordinance na may height limit yung mga buildings So, kailangan na rin yung sundin. So, that's also a limitation on your right as an owner to build a property on your parcel of land. So, kung gusto mo sobrang taas na building, diba, or something, pero may limitations, may mga ordinance sa mga ganyan. Kaya nga may building permit Diba? He cannot complain on the unreasonable requirements of aerial navigation. When it is necessary to build, construct, or install in the subsurface or subterranean portion of private and government lands owned, occupied, or leased by other persons, such infrastructure as subways, tunnels, underpasses, waterways, floodways, or utility facilities as part of the government's infrastructure and development project, the government or any of its authorized representatives shall not be prevented from entry into and use of subsurface or subterranean portions of such private and government lands by surface owners or occupants if such entry and use are made more than 50 meters from the surface. So, what is the doctrine of self-help? The requisites for this doctrine to apply are first, the use of force as may be reasonably necessary. Second, it is the owner or lawful possessor who exercises the power. Third, that there is actual or threatened physical invasion or usurpation. And fourth, that there is no delay in one's exercise. So, this doctrine can only be exercised at the time of an actual or threatened dispossession or immediately after the dispossession in order to regain possession. Only once delay has taken place, even if excusable, the owner or lawful possessor must resort to judicial process for the recovery of property, for he is no longer justified in taking the law into his own hands. So, crib na to, like, self-defense din kasama yung property, your defense of property. Actually, di ba, merong case na ganito. na binabakuran yung lupa niya, nilalagyan ng fence, tapos binaril niya, hindi siya magka-qualify kasi hindi reasonable yung force used, hindi, so parang excessive, so kailangan reasonable yung use of force, and ayun, yun yung kulang sa kanya. For example, hinold up ka, ibibigay mo na lang ba? Hindi. Syempre, you have to help yourself and you also have to defend yourself. It's your choice really kung bibigay mo na lang or hindi. Pero if papalag ka, then that's not against the law and you may be justified as a form of self-defense for defending your property. So, again, right to life, liberty, and property, diba? Meron tayo as citizens. So we have the right to defend such rights. Ang redundant. But yeah, you get the idea. Doctrine of incomplete privilege or state of necessity. Under this doctrine, the owner of a thing has no right to prohibit the interference of another with wait lang, may mga typo ako, just gonna fix to prohibit, nasa na ako, to prohibit the interference of another with the same. If the interference is necessary to avert an imminent danger and the threatened damage, compared to the damage arising to the owner from the interference, is much greater. It is exception to the general rule that a person cannot interfere with the right of ownership of another. So, pag-usapan naman natin yung mga actions na you can take in order to defend your property or to redeem your property. So, first, Accion Interdictal or action for ejectment. It's a summary action for recovery of actual, material, or de facto physical possession through an action for forcible entry or unlawful detainer filed with the municipal trial court or metropolitan trial court. So, forcible entry, kailan ka magpa-file for action for forcible entry? If the possession of another was already unlawful at the time. Unlawful detainer naman is the possession was first lawful but became illegal. So, anong example? Forcible entry, kapag ka, for example, meron kang property like bahay or sabihin na natin condo. Tapos, nagsistay siya doon without your authority as owner. Pwede ka mag-file ng action for forcible entry. Unlawful detainer naman, at first legal. For example, lessee mo siya. Lessor ka, ikaw may-ari ng condo. Tapos, hindi na siya nagbabayad ng rent. Sobrang tagal na, mga 6 months na. Diba? So, hindi na pwede. Ayaw pa niyang umalis. Diba? Or, isang better example, I guess, na mas madali intindihin is if still, merong lease agreement, kunwari condo, tapos for 1 year lang, good for 1 year. Lagpas na ng 1 year, expired na yung lease contract, pero hindi pa rin siya umaalis. Ganyan. So, yung proper action is unlawful detainer. So, sa forcible entry, lawful possessor is deprived of property through force, intimidation, strategy, threats, and stealth. Sa unlawful detainer naman, the possessor refuses to vacate upon demand of owner. The lawful possession by permission or tolerance becomes unlawful due to failure to vacate. Sa forcible entry, action may be brought 1 year from the dispossession or from knowledge thereof. Unlawful detainer, action may be brought 1 year from the time the last demand to vacate was made. So, Accion Publiciana, also known as Accion Plenaria de Possession, is an ordinary civil proceeding to determine the better right of possession of realty independently of title. It refers to an ejectment suit filed after the expiration of 1 year Kasi diba, sa forcible entry, unlawful detainer 1 year. From the accrual of the cause of action or from unlawful withholding of possession of the realty. The objective of the plaintiffs in an Accion Publiciana is to recover possession only, not ownership. However, when parties raise the issue of ownership, the courts may pass upon the issue to determine who between or among the parties has the right to possess the party. What party? Realty. Ano ba yan? Or property. However, such adjudication is not conclusive on the issue of ownership. Actions for ejectment not filed within 1 year prescriptive period must be filed as Accion Publiciana. So, kung hindi ka na nakafile ng forcible entry or unlawful detainer within 1 year from the dispossession or from knowledge or from the last demand to vacate was made, then Accion Publiciana is a proper action or proper remedy. Accion Reinvindicatoria. Accion Reinvindicatoria. Sorry sa pronunciation ko. It's an action whereby plaintiff alleges ownership over a parcel of land and seeks recovery of its full possession. It seeks the recovery of ownership and includes jus ottendi, or the right to use, and the jus fruendi, the right to the fruits, brought in the proper RTC. So first, the property must be identified, and second, that the plaintiff must rely on the strength of his title. So what is replevin? For manual delivery of movable property for either ownership or possession. The party praying for recovery of the possession may, at the commencement of the action or at any time before such action, apply for an order for the delivery of such property to him. So the applicant must show that he's the owner of the property claimed and that he is entitled to the possession, and there's a particular description of the property claimed, and that the property is wrongfully detained by the adverse party, alleging the cause of detention thereof to the best of his knowledge, information, and belief, that the property has not been distrained or taken for tax assessment or a fine pursuant to law, or seized under writ of execution or preliminary attachment, or otherwise placed under custodial leges. If the property is so seized, the applicant must show that it is exempt from seizure and, of course, actual market value of the property. So now, what is quieting of title? A common law remedy for the removal of any cloud upon a doubt or uncertainty with respect to title to real property. It is done to put a stop to vexatious litigation in relation to the property. So the requisites are: the plaintiff has legal or an equitable title to or interest in the real property subject of the action, and he need not be in possession of said property, and the deed, claim, encumbrance, or proceeding claimed to be casting a cloud on plaintiff's title must be shown to be in fact invalid or inoperative despite its prima facie appearance of validity or legal efficacy. So, quieting of title kapag magulo kung sino yung may-ari, to resolve the confusion. Usually, merong quieting of title kapag for example, merong property na pinaparentahan. Tapos, yung lessee confused kung kanino niya ibabayad yung rent kasi nagkiklaim yung isa na entitled siya sa rental payments. Yung isa naman sabi niya siya may-ari. So, kanino siya magbabayad? So, usually yung ginagawa niyan is i-co-consign, tama ba yung term co-consign mo sa court kung kapag ikaw yung lessee, tapos i-resolve muna kung sino talaga yung entitled dun sa rental payments, and they have to clear the cloud, kumbaga quiet the title and find out who is the owner really. So it's inapplicable to questions involving interpretation of documents, mere written or oral assertions of claim, except if made in a legal proceeding or asserts that an instrument or entry in plaintiff's favor is not what it purports to be. For boundary disputes, deeds by strangers to the title unless purporting to convey the property of the plaintiff, to instruments invalid of their face, or where the validity of the instrument involves a pure question of law. So such cloud must be due to some instrument, record, claim, encumbrance, or proceeding which is apparently valid but is in truth invalid, ineffective, voidable, or unenforceable, and is prejudicial to the plaintiff's title. The plaintiff must return to the defendant all benefits that he may have received from the latter or reimburse him for expenses that may have redounded to his benefit. An action to quiet title applies to real property, except to some personal properties like vessels or stock certificates, which partake of the nature of real property, or when are considered as real property because of special registration requirements. Any person interested under a deed, will, contract, or other written instrument, or whose rights are affected by a statute, executive order, or regulation, ordinance or regulation, may, before breach of violation thereof, bring an action to the appropriate RTC to determine any question of construction or validity arising and for declaration of his rights and duties thereunder. So, action to remove or prevent a cloud, a semblance of title, either legal, party is the registered owner, or equitable, party has beneficial ownership, or a claim of a right in real property, appearing in some legal form, but which is in fact invalid or which would be inequitable to enforce. Its purpose is to cancel, deliver, remove, or release an encumbrance which can be considered a claim regarding plaintiff's title. So the requisites are that the plaintiff has a title to a real property or interest therein. The defendant is bent on creating a cloud on the title or interest therein. The danger must not be merely speculative or imaginary but imminent. And unless the defendant is restrained or stopped, the title or interest of the plaintiff will be prejudiced or adversely affected. So that's it for ownership in general. Meron pa tayong topic for ownership, and that's modes of ownership, wherein we will be discussing occupation, donation, prescription, intellectual creation, testate and intestate succession, and tradition. Pero yung mga to, like intellectual creation, best discussed kapag we're talking about intellectual property law. Testate and intestate succession, there's an entire set of videos for that na separate pa. Tradition, so we also have to discuss sales, mga ganyan. Traditions, delivery, basically. Pero yung i-discuss natin sa next video with regard to modes of acquiring ownership is parang pasadahan lang, hindi naman talaga sobrang deep na level. Yeah, mas okay na separate. Tapos isama na rin natin siguro yung accession, kasi it's also one of the which is quite long. Alluvium, mga iba't ibang modes of ownership. It's gonna be a long video, I think, the next one. So ayun. So thank you. Bye.